It's a great pleasure and a great honor to speak to you and to participate in your project, Professor Girard. One or two preliminary remarks before I embark on the substance of my talk. First of all, I'm going to speak entirely about English law. That's not because, unlike some of our politicians, now an English nationalist. It's because Scots law, which is actually a mixed system of common and civil law, hasn't contributed, in my view, very much in this area. And also, when Ireland has a common law system, but it also has a written codified constitution, which explicitly guarantees freedom of expression and has developed a slightly different case law with which I'm not particularly familiar, but I will probably, when I write my chapter, devote a small section to some leading Irish cases and principles which contrast with English law. The second preliminary point is this, that as I understand it, your research project and the book will look at the role of freedom of expression in political debate and in promoting and strengthening a democracy. Well, that, of course, seems to me to raise political questions which could only be resolved to some extent by empirical research, by studies of election campaigns, of political debate. I'm not going to attempt to talk about those empirical questions. My approach will be almost entirely legal, looking at leading legal principles and cases which encapsulate the principles of freedom of speech, freedom of expression. Another preliminary remark is this. Do we have a coherent sense of a democracy? There are many theories of democracies: representative democracy, direct democracies, deliberative democracies, and there are some others. I'm not going here to discuss them very much, though I might touch on one aspect of this debate towards the end. Suffice to say at the start that historically, and I think still, the UK, or England if you like, is a parliamentary democracy. A democracy which at its core lies in the election of members of parliament from which a government is formed, and freedom of expression is most important in allowing freedom of political debate during election campaigns and, of course, between elections. This feature of England or the United Kingdom is reflected in Article 9 of the Old Bill of Rights of 1689, which states broadly that the freedom of speech and proceedings in Parliament must not be questioned in any court. And in practice, this means that members of Parliament and members of the House of Lords, peers, are free in the context of parliamentary debate to say anything they like without any possibility of legal sanction, redress, civil action for defamation, and so on. That is the most absolute freedom of expression that exists in the informal, uncodified UK constitution. It goes much beyond the practical freedom of speech or expression, which is enjoyed by all of us our citizens when we debate politics. Well, now I'll move on to the substance of the talk, and there are really four parts to this. First of all, the common law position before the great constitutional change made in 1998, when the United Kingdom incorporated the European Convention on Human Rights and Fundamental Freedoms into our law. And since then, there has been a significant change in the extent to which freedom of speech or expression is protected. Incidentally, another preliminary point, generally speaking, English lawyers talk about freedom of speech, although, of course, the European Convention and continental jurisprudence talks about freedom of expression, liberté d'expression, Meinungsfreiheit, and so on. And I don't think there's any real distinction between them. Freedom of speech equals freedom of expression to all intents and purposes. Well, first of all, let me state what I understand to be the general common law position, which remains in a way the common law position, although it's been radically modified, maybe one says changed, by the Human Rights Act of 1998. I'm taking these principles from the most influential work on constitutional law ever written in Britain, and that is Dicey's Introduction to the Study of the Law of the Constitution, written as long ago as 1885. And his principles, although well over 130 years old now, are still taken seriously by constitutional experts and by politicians. What he said about freedom of speech was this, that the freedom exists where the law doesn't intervene. It's, if you like, a residual freedom. If there's no law against it, you're free to say or write what you like. And the same goes for other related freedoms, freedom of assembly, freedom to demonstrate, and so on. He contrasted the English law with the position in continental Europe. He particularly contrasted the law in England with the law in Belgium, where freedom of expression was guaranteed by the then relatively recent constitution of 1830, I think. He says that the provision in a constitutional text is in a way quite vulnerable to amendments and to change and modification, whereas the English position, where you have freedom of speech, absolutely, where the law doesn't intervene, has, if you like, slightly stronger security. Myself, I find this a puzzling position, but we don't want to go, I think, into the complexities of Dicey's argument. There were, of course, as Dicey discussed in his treatment of freedom of speech, a number of significant restrictions on the exercise of freedom of speech, particularly the common law offenses as they were then of seditious libel, blasphemy, obscene publications, and defamation or libel law. And those imposed significant restrictions on what it is that we could say and write. The law was modified in some respects by statute, which always trumped, if I could use that word, or took primacy over case law. For example, an act of 1843 established that truth justification was a defense to a libel action. Before that, that wasn't the case. The law of obscene publications was put on a statutory basis in 1857. And more recently, the offences of blasphemy and sedition have been abolished by statute, though blasphemy has been replaced by incitement to racial hatred. In practice, of course, the exercise of freedom of expression in practice left much to a decision in a particular case, to the judgment, as Dicey himself said, to the common sense of the jury. Prosecutions for blasphemy, for obscene publications, for sedition, and also libel actions were tried before a jury of 12 members. And if they thought the offence amounted to the publication amounted to the offence of sedition or blasphemy, there was a conviction. Otherwise, the defendant would be acquitted. These principles remained unaffected in any significant way until the post-war period. But I think it's possible to detect in a number of judicial decisions, this is really the second part of my talk, a number of judicial decisions in the 1950s, 1960s, and so on, and then increasingly in the 1990s, when the courts developed the law in anticipation of the likely incorporation of the convention into our law. They developed the law in a way which is slightly more sympathetic to freedom of expression. First of all, the courts quite often began to treat freedom of speech not just as something which existed where the law said nothing, but as a legal principle. I don't know how many of you are legal philosophers, but Dworkin famously draws a distinction between a rule of law and a legal principle, which has a weight depending upon the circumstances of the case. Well, freedom of speech, it seemed to me, began to emerge in the 1960s and 70s as a legal principle which the courts began to take account of in cases where the facts suggested the principle ought to be accommodated. I'll give you some examples. It was treated as a principle which might shape the development of the common law. I'll give you one or two particular instances. The House of Lords, which was then until 2004-05 our top court, held that a public authority could not bring proceedings for defamation, had no legal capacity to sue. And it said that was required by common law principles of freedom of speech. The defense of fair comment to a libel action was given relatively wide scope, very wide scope, because of the courts taking account of freedom of speech or expression, so that it's not really a defense of fair comment, but a defense of honest comment. The court makes no assessment as to whether the comment, the expression of opinion, was objectively fair. It's as long as it was held honestly by a non-malicious publisher. And then a very old principle going back to the end of the 19th century, 1893 decision of the Court of Appeal, a claimant in a libel action can't get an interim or preliminary injunction, I forget the French equivalent, to stop republication of a libel before full trial of the action, because otherwise there would be damage to freedom of expression of a defamatory allegation which might be held to be true or covered by a defense of fair comment. That's a very old principle which still represents English law. A second point, freedom of speech could be used to limit the scope of a statute. And I've given you one example of that in the synopsis. The House of Lords decision in Brutus against Cousins, that involved demonstrators interrupting a tennis doubles match at Wimbledon, featuring a South African player. It was an anti-apartheid demonstration. The crowd were very fed up with that and began to shake their fists and shout. The demonstrators were prosecuted for the offense of threatening, abusive, or insulting words likely to occasion a breach of peace. And the House of Lords said insulting it should not be treated in the same way as offensive. The demonstration could be regarded as offensive or very irritating or annoying, but it didn't actually insult the spectators. So the principle of freedom of expression is here used to limit the interpretation of a statute. Now, this principle has been taken further, as I'll explain in a few moments, under the Human Rights Act. Fourth little point, the courts, however, could not entertain a challenge to the legality or constitutionality of a statute, a law passed by Parliament, on the ground that it infringed freedom of speech. The then leader of our extreme right-wing party, Colin Jordan, attempted to challenge in the courts the introduction of the offence of incitement to racial hatred, or hate speech offence, in 1965. And the court said, we will not hear an argument that the law is invalid because it infringes freedom of speech. That you can't make that argument before an English court then, and now you can, but as I'll explain, in a very limited way. So English courts, Scottish courts, have no jurisdiction to invalidate an act of Parliament on freedom of expression or other civil liberties grounds, unlike the position in the United States or Germany, or, though I'm not so sure about this, the position in France, which is now quite complicated. Right, now for the change introduced by the Human Rights Act. What the Human Rights Act of 1998, it was one of a series of major constitutional law reforms introduced by the Labour government under Tony Blair's premiership. The Human Rights Act incorporates the European Convention on Human Rights, of course, including Article 10, the guarantee of freedom of expression about which Françoise Tulkins spoke last week. Under the Act, courts must now interpret all legislation so far as possible in conformity with the right to freedom of expression and other guaranteed human rights, Section 3 of the Act. But if they can't do this, they can, if the argument is made, make a declaration that the United Kingdom Parliament law is incompatible with the Convention on Human Rights, but it can't invalidate it. So it has a jurisdiction which stops short of the powers of the Bundesverfassungsgericht, or the United States Supreme Court. If it makes a declaration of incompatibility, it is then for Parliament to put the matter right. which it has done in the handful of cases in which a declaration has been made, but none of them have been freedom of expression cases. I'll mention another provision which I didn't summarize in the synopsis. Section 2 of the Act requires the courts to take account of European Court of Human Rights decisions, but they're not required to follow them. And we'll see when I discuss the animal defenders case that there is one House of Lords decision where the European Court decision was not followed. Well, I'll now mention some cases of the House of Lords, as then the top court, now the Supreme Court, which show the significance of the Human Rights Convention incorporation in our law. And they also bring out some interesting points about the significance of freedom of expression in the context of democratic government and freedom of political discussion. The first one actually is a case decided before the Human Rights Act, but it was quite clear that the Human Rights Act was going to be introduced and enacted. Ex parte Sims, a very significant speech by one of the great liberal judges in the House of Lords, Lord Steyn, a South African, interestingly, who says that the freedom is the lifeblood of democracy. It provides a brake on the abuse of power. It enables those who are governed to see what is going wrong with government. And in the particular case, he and the House of Lords invalidated delegated legislation, prison orders, because they stopped prisoners discussing their convictions with journalists without the permission of the governor. And the House of Lords ruled that is an intolerable infringement of freedom of speech because it prevented, in practice, prisoners raising in public their disquiet as to the safety of their convictions, and that prevented the public being aware that the legal system was not infallible. There are similar statements of principle in Shaler, a case decided after the Human Rights Act was in force, when Lord Bingham, perhaps our greatest judge in the post-war era, said that freedom of speech was extremely important for the working of a democracy, that a participatory democracy means government by the people, of the people, for the people. And it is an ongoing participatory process. And in that role, the media play an important part. Now, I'll develop that with a reference to the next case. This is Reynolds and Times newspapers, which is the foundation now of modern English libel law, because it significantly expanded the defenses available to the media when they are sued for libel or defamation. The argument was made before the House of Lords that there should be a broad defense of qualified privilege for non-malicious publications on politics for newspapers and other branches of the media. But The House of Lords rejected that. They did not think, this is an important point, that discussion of politics should be distinguished from discussion of all matters of public interest. First of all, they said it's quite impossible in practice to draw a sharp line between a discussion of politics and a discussion of public interest matters. And secondly, even if you could try and draw a line, it would be wrong in principle to do so, because there are many matters of public importance, corruption and so on, which of course are purely a matter of politics, but are a matter of ethics in business and so on. And so he refused to accept that argument, but he did accept a defense for allegations, defamatory allegations, published in the public interest, whether true or not, provided the media satisfy the requirements of responsible journalism. And I'll come back to that in the next part of the talk. The next case, Pro-Life Alliance. This is a very interesting one where the argument of freedom of speech was rejected. It involved the application of broadcasting rules to a party election broadcast by the Pro-Life Alliance Party, which campaigns against abortion. It had, under the rules, the informal rules agreed by political parties and the broadcasters, a right, an opportunity to make a party broadcast, election broadcast in Wales. The rules about the number of seats it was contesting. But there's a general rule that no broadcast should infringe taste and decency, should be grossly offensive to viewers. And the Pro-Life Alliance Party wanted to show pictures of aborted fetuses, which the BBC rules would be in infringement, would infringe the taste and decency rule and be very offensive to viewers, or might be. This was challenged by the political party in the courts. They succeeded in the Court of Appeal, but in the House of Lords, they failed by a majority of 4-1 judges. One of the judges, Lord Hoffman, said this wasn't really engaging the primary right of freedom of expression, because it was really a question of the rules applicable to those allowed access to broadcasting channels to communicate an election broadcast. I'm not sure whether that's right or not, but he said that was the case. But the ruling of the majority was the taste and decency rule applied without qualification to a broadcast political election broadcast. So there was no special allowance made by the House of Lords, unlike by the Court of Appeal, the court below, for political election broadcasts. The final case I'll mention is also about a broadcast advertisement, Animal Defenders International, a decision of the House of Lords, I think, in 2005. Under our legislation, there is a statutory ban on all political advertisements, apart from the permitted party, political, and election broadcasts. But outside those permitted broadcasts, no party or pressure group can pay for an advertisement. I don't know what the position is in France or Germany. It's certainly not the case in America. But in this country, in the United Kingdom, that's a very strict rule. This was challenged by Animal Defenders International, who wanted to make a short advertisement protesting against the use of animals for scientific and medical research and the cruel treatment of animals generally. It was rejected by the lower courts and also by the House of Lords on the ground that a total ban was the only practical way of preventing rich pressure groups buying up much more time than less well-off pressure groups. And therefore, a total ban, although it reached very wide, was justifiable. And here you've got a case where freedom of expression runs up against equality arguments. And here the equality argument won. And the House of Lords said, well, of course, the Animal Defenders International Group could insert adverts into newspapers, they could advertise in other ways, they could leaflet, they had a freedom of speech, but the broadcasting ban was justifiable and a necessary restriction on the exercise of the freedom. And now another short section, the role of the media, particularly in the context of defamation. And I'll go back briefly to the Reynolds case. In Reynolds, the role of the media was emphasized in the leading speech of Lord Nichols, who upheld the argument that there should be a broad public interest qualified privilege for reporting defamatory allegations. He said, in practice, freedom of expression depended on an active media which investigated allegations, which reported them in good faith, provided they satisfied requirements of responsible journalism. That meant they must check their sources, they must contact the subjects of the allegations, they must publish the claimant's comments, the story must be extremely important, and there must be some urgency in publishing, and so on. One of the most interesting questions now is, how is those principles to be applied to the social media and citizen journalists? There have been one or two cases which have held that the new qualified privilege media defense does apply to everyone, and that the requirements of responsible journalism must be applied flexibly in the case of citizen journalists. You can't expect them to take all the steps that you would require of a qualified journalist working for a newspaper or other media organization. Now for the last section of the talk. Under the traditional common law, freedom of speech or expression is a residual liberty. It exists where the government does not intervene. That seems to me to be tantamount, equivalent to saying that freedom of speech is what is sometimes called, applying the great distinction drawn by Hofelt, a negative liberty, which exists against the government, it doesn't confer positive rights imposing duties or obligations on the government. We can come back to that if you find that puzzling, but I think it should be clear. This position might now be different because of the guarantee of the right to freedom of expression incorporated in our law under the Human Rights Act. So are there any indications that English law, United Kingdom law, recognizes a positive right to freedom of expression and treats it as something more than a bare negative liberty? Well, there may be a handful of indications in our law that freedom of expression is recognized as a value which must be taken account in certain contexts, which influences the requirements of legislation, although I think it stops short, well short, of a positive right. Let me give you some examples of how freedom of expression exists in our rules and can't therefore be said to be a bare liberty. All our broadcasters, or at least our public service broadcasters, are required to broadcast news and also show due impartiality. They can't take the editorial line that the press and magazines are free to. Now, that seems to me to represent requirements of freedom of expression, the balancing of one view against another. What in continental jurisprudence is required is regarded as the principle of pluralism, which means that broadcasting channels cannot be used for one strand of opinion. Another example of this principle, when deciding on a press or broadcasting media merger, the monopoly authorities, now the Competition and Markets Authority, is required in certain circumstances to take into account the plurality of views or the diversity of views and the interests of freedom of expression. And that is perhaps, and this has been taken account of by a complex Court of Appeal decision, this is perhaps a clear representation of the value of pluralism in our law. But I think this stops short of a clear positive right. Let me give you one or two examples. We have no right of reply to an unfair broadcast or article in the press. There's no equivalent of the droit de réponse in French law, and there's similar rights in German law. We don't have that right. I think we ought to, but we don't. There's no right to press subsidies, as there is, I think, in Sweden. Local newspapers, which are in serious economic parlor state now, are free to decline. There's no subsidy, no right of political parties to subsidies. There's no system for allocating public funds to political parties as there is in Germany. There is no guarantee of impartial appointments to the BBC governing body or to senior officers of the BBC. That's purely a matter for the Secretary of State, a member of government. There is no objective limit or limit of any sort on adequate financing of the BBC through the license fee. That's determined by the government. That's in great contrast to the position in Germany, where there is a strong guarantee of fair fixing of the license fee arrangements. We do have now freedom of information. but it's been said by one of the law lords in the BBC and sugar case, that that's not really an aspect of freedom of expression, but an independent statutory right. Well, I think I will end there. I've got some questions I would quite like to raise for discussion, but in a way I think I've talked for, well, 50 minutes now, 3/4 of an hour. I'd like to take questions, and I hope my exposition was clear. I am aware that you're all non-native not English speakers. You all